Now it's the final session of the webcast where Just Legal have a look at some of your questions that have come in to us over the afternoon. Kirsty McLaughlin has been busy collecting these for us, and we're joined again by Jason and John.
So the first question relates to the cyberbullying scenario, and it asks, how can tutors balance things told to them in confidence by students with their legal duty to report incidents? For example, if the student knows the tutor is required to report information, this might deter them from revealing their problem.
I think that is a training issue for colleges. They have obligations to provide training for all staff, and I think a part of that will be that you cannot guarantee to a student if they start to disclose information of that nature to them, they can't guarantee that they won't then report it to another party. They have to make the student aware that that's going to take place. So that's I think that's an issue for training for staff within colleges.
I think most colleges will have had to handle this type of situation before anyway, where they've got to have people who can liaise with the students and can build a level of trust with them when confidential issues like that or bullying or anything that has to be dealt with. So they've had to deal with this already. So I think moving it on into the new technologies is part of what has to be done as well. So maybe some, as you say, training or making sure that's covered by your training would be important to include.
And as a final part of that, I would add it should be clear in each circumstance whether there is actually a legal obligation to reveal to someone the situation, and they are actually going to be, I think, reasonably rare. There is an obligation maybe to do something as a result of the incident and do something with the information, but that might not involve releasing confidential information.
Right. Well, I hope that's helped. So the second question goes on to references throughout the webcast about colleges' legal obligations and asks, does that apply to all post-16 learning providers?
Oh, I'll answer that. And obviously the duty that we're talking about for the whole is the duty of care. And that's a very general concept that applies to individuals in their daily lives when we're doing things like driving. So it's not just about colleges, it's about all institutions, all post-16 learning providers, indeed any organisation or indeed individual in what they do. This assessment must be made of what risks are inherent. So it will apply exactly in the same way to post-16 learning providers as it does to colleges. Likewise, if there's evidence of a criminal offence having been committed, the going off to the police and dealing with them applies equally to other post-16 learning providers and indeed pre-16 learning providers as well.
Well, that's a good point you make there, Jason, because we have had quite a few questions about the different ages of students and also different locations for their learning. So going on from that, the next question is what CRB checks do we need to have in place when a student is on a work experience placement?
Yeah, basically there's been quite a bit of concern regarding CRB checks, who has to have them. There's been a bit of clarification on that line, when you need one and when you don't need one, and I suppose the categories are frequent and intensive contact with under 18s. I think if a student is on a work experience placement, then if there's somebody within that placement, a business or whatever, that has a kind of main supervisory training role for that student, and they're working with them perhaps on a one-to-one basis, then they're likely to need a CRB check. And I think the difference here needs to be made between somebody who's in that role and someone who's merely just, for example, comes into contact with that student because they're in the same type of office area and so on. So I think it goes back to the specific role of that individual, and quite often from looking at different guidance that's available, it would appear there's some relationship between the college and the work placement. There's some kind of child protection agreement in place or a statement of principles and so on. And I think it's also important that if the person is required to have a CRB check, if they have that kind of supervisory role, then they also are required to receive training on how to deal with child protection issues.
So looking at obviously the individuals, the students coming into contact, does the age of the student affect that? For example, if the student's under 18, and also looking at when they leave the college premises, is what you've already discussed, but when they are coming into the college premises on a day release, for example, as part of a work-based learning, how would that affect that?
Well, I think if the students are, let's say they're under 16, and the situation might be where they're coming to college for a day, they're actually enrolled with a school, for example, I think that probably as the main provider, the school and indeed the local authority will want to satisfy themselves that there are adequate safeguards in place. Probably there would be some arrangement between the school and the college. There would be an agreement as regards child protection policies and procedures, and I think, as Jason mentioned earlier, if there's a child protection order or there's specific higher safeguards that are required, then they will need to be in place and confirmed that that's the situation.
I think that clarifying who has responsibility would be part of the preparation that you would do. And obviously if a college is taking day release workers, then that part of the agreement would, at the start or set up, would need to, as I said, make clear who has responsibility for ensuring those that have regular and intensive contact, that the checks are done. And in some places that will fall on the college, and other times it will fall on the employer. But it's something that would need to be closely examined, and I think that it's, as it was said earlier, I think it's the responsibility to the individual child really is what really should be the important, is what we should be determining how we're looking at these matters.
Just with regards to that, I mean, another situation that's I've come across or I've been asked about is if, for example, you have an under 18 who is a student at the college and they are on, let's say, a placement in a school or a nursery or something like that, are they required to have a CRB check? And I think that's quite a difficult question to answer, because it will depend to some extent on the circumstances. I mean, the Independent Safeguarding Authority are kind of going towards the direction that 16 to 18-year-olds shouldn't be or shouldn't require to be ISA registered. But I also, on the other hand, I think if a student's in a college and it's part of their training, they're training to be a student teacher, they're training to be a student nursery nurse, then probably that will, or it should be part of their enrolment process, that they accept that they will have to have a CRB carried out before they accept the place on the college, as part of their training, as it were. So I think it's quite tricky in some situations, but there's an awful lot of information and guidance on this on the Inspectorate's website, particularly Ofsted, so it's worth having a look there.